Hope you all are doing good. So we have started with Unit 2 yesterday in Sale of Goods Act, and the topic was condition and warranties. Hope you all remember that because we will be taking the second half today. So yesterday, what we discussed, let me just quickly revise it for all of you. So we discussed, first of all, regarding the stipulation as to time. So stipulation as to time, that is section 11. It says that in a contract, there can be two situations. One is with respect to the time of delivery and time of payment. So for time of delivery, it is an important part of the contract, but time of payment is not material for the contract. So that is one thing which we studied. Second thing is that we started with the definitions of conditions and warranties. So it is contained in section 12. So 12.2 specifically says that condition, the meaning of the term condition. So condition is a stipulation which is essential for the main purpose of the contract and the breach of which gives right to. So what rights it gives? It gives right to reject the goods or return the goods basically, or repudiate the contract and claim for the damages, right? So that is the thing, right? Very well mentioned by Duty Noy. So Duty Noy. So sorry if I have spelled it wrong. So let it be. Pragati, hi Pragati. And the second part, 12.3, the definition of warranty. So warranty simply said that, again, warranty is a stipulation which is collateral to the main purpose of the contract. So collateral means it is secondary, it is not that important. So if there is a breach of guarantee, in that case, what are the rights given to the buyer? Buyer cannot reject the goods. That means he cannot repudiate the contract, but he can only claim the damages. Correct. So Dutimo, you are right. Okay. So next, again, we studied that condition can be converted into warranty, and there are various situations or there are various circumstances in which condition can be converted into warranty. And there was one more topic which said that even if the parties have used the terms vice versa or any other terms they might have used, the construction of the contract actually determines whether it is condition or warranty. So if the ultimate intention of buyer or seller is like that, if this particular thing is not fulfilled, if this particular stipulation is not fulfilled, we will treat as if the contract has been cancelled. So in that case, it will be treated as condition. In all other cases, it will be treated as warranty. So these are the two things which we studied. Then we started with various implied conditions and warranties. We started with the list of that. So basically, again, let me walk you through why we have been studying this. So broadly, condition and warranties have been told to you. But again, the topic says that there are some express conditions and warranties and there are implied conditions and warranties. Express are those which are mutually discussed between the buyer and seller. So when you are going to a shop for purchasing something, or whenever you are doing any transaction, and in which you are mutually deciding or mutually discussing these kind of stipulations, then in that case, that will be known as express. So whether you are verbally discussing or you are taking that on writing. So in that case, that will be considered as express condition and warranty. And there can be any, number of express conditions or warranties. However, even if you have not discussed anything, there are some things which are implied by law. So even if you have not discussed, what are the circumstances when you can return the goods? So all those circumstances are listed, and therefore it is known as implied conditions. And where all you can just claim the damages, you cannot return the goods, those are considered as implied warranties, and they are listed in the Sale of Goods Act. So we have to read out that, we have to understand that, and based on that, some case studies are also asked in the examination. So today we will discuss all that in detail. And then the last topic will be caveat emptor, which says that buyer has to beware. So buyer has to beware means normally most of the rights are given to the buyer. However, again, it is the duty and responsibility of the buyer that he himself has to be very careful at the time of, purchasing anything, any goods. So that is what the whole topic will be about. So let me quickly share my screen first of all. I hope you all remember all this. Yes. So how many conditions are there? How many warranties are there? Just write it in the chat box if you remember. Implied conditions and warranties I'm talking about. And if you remember the names of a few, that will be great. I hope my screen is visible. I'm just making it full screen for all of you. So has anyone mentioned it in the chat box? Let me quickly check that. So Ananya says that conditions may take express and implied. That is true. And Gangula is saying that there are 7 conditions, 7 implied conditions. We should be very specific while writing also. So then Akshat has mentioned 1, 2, 3, 3 conditions, 3 implied conditions he has mentioned. Okay. But incompletely you are writing. Never mind, never mind. So in short, you have mentioned something or the other. Let it be. So let us quickly start with the names and then we will discuss them in detail. So the first implied condition was condition as to title. Title again simply means wherever this word title is used in Sale of Goods Act, it means ownership rights. Okay, so basically whenever we are discussing in the Sale of Goods Act, one person is transferring the title to the other. Okay, so whole unit 3 will revolve around this particular term, title. So when this ownership is passed on. So if the seller has the ownership, then only he can pass on the ownership to the buyer. So therefore, it is very important that at the time of sale, the seller should be the owner of the goods. And that is the condition. So if the seller himself is not the owner, he cannot pass on the title, he cannot pass on the ownership to the other person. So it is implied condition that because buyer cannot ask whether these goods belong to you, or normally we do not ask. We assume that if the goods are lying with the seller, it means that they belong to him or it belongs to him. So ultimately, it is an implied condition that if sometime later it is found out that this person is not the owner, then what are the rights for this buyer? So that is what we will discuss in detail. Next is sale by description, then sale by sample as well as description, sale by sample, sale condition as to quality or fitness. This 16.1 is again important from the point of view of case studies. You'll find many case studies on this particular topic and it has some exceptions also. So we will study that as well. Next is condition as to merchantability and last is condition as to wholesomeness. For wholesomeness, you have to remember it applies only to eatables, something which you eat or drink maybe. So it applies only to that. So that has to be fit for consumption. So whatever you are purchasing, anything which you are purchasing to eat or drink, that should be fit for consumption. And all other things besides eatables will fall into this section 16.1, that is condition as to quality of fitness. So suppose you are purchasing furniture or you are purchasing any other electronic goods or whatever, it should have a proper quality, it should have proper fitness, it should be fit to use. So that is contained in this condition as to quality or fitness. Okay, what are the various warranties? Let us just quickly go through the names. We will obviously discuss them in detail in the further slides. So first is warranty as to undistributed possession. Second is warranty as to non-existence of the encumbrances. These first 2 points are basically related to your condition as to title. So these are, subordinates to these conditions. So if you follow this condition, automatically warranties, these 2 warranties are also associated with this part. So we will discuss obviously in detail later on. Next is disclosure of dangerous nature of the goods. So yesterday we saw some or we discussed some examples wherein I mentioned that in few of the cosmetics or any medicine or any products, wherein there is a warning. In the wrapper itself, there is a warning which maybe it indicates that it has to be stored in a cool place or it should not be used by some allergic person or it should be kept away from the children, like that. So dangerous nature of the good should be disclosed. So warning should be given basically. And if it is not, then obviously if any injury has happened because of those kind of goods, then you can claim the damages from the seller. Next is warranty as to the quality or fitness by use of trade. So again, this you can associate with this or correlate with this condition as to quality or fitness. So if goods are of proper quality or fitness, then what happens? And if they are not of proper quality and fitness, obviously you can reject the goods and also you can claim damages. So these two go simultaneously. Okay, so now we are discussing all of this in detail. So are we ready to go? Let me quickly know it from you all. Are we ready to discuss all this in detail? Write yes in the chat box so that we can start. Thank you, Shri, Ikra. Okay, Dutimoy and Samarth. Okay, I'm not taking all the names, but okay, great. So what is the first implied condition? So first implied condition is regarding title. So that is the ownership right. And again, wherever this term is used, just mention it for yourself. It means title. Title means the ownership rights. Okay. And this is contained in section 14, clause D. So what does it say? So there is an implied condition that the seller has the right to sell. Again, just read it carefully. It says that seller has the right to sell. So obviously, if seller does not have the right to sell, how can he pass on the title or the ownership to the buyer? Therefore, it is assumed or it is, it has to be there basically that whenever a person who is considered as a seller, whenever he is selling the goods, he should always have the right to sell. And if he is not having that right to sell, what are the rights available to the buyer? Since it is a condition, obviously the buyer can. So if this condition is breached, the buyer will have the right to reject the goods or repudiate the contract and can claim damages also from the seller. So that is the thing. But what you have to understand here is, when does this seller has the right to sell? So when does he has the right to sell? Let us see that. He has the right to sell. If the seller has no title, the buyer may have the return the goods. This is the ultimate effect. The buyer can recover the price from the seller. This is the ultimate effect. Okay. And when does the seller has the right? He should have the right in case of sale. He should have the immediate right uh, of ownership, and in case of agreement to sell, maybe at the future date he can have a right to sell. So we will understand this with the help of an example so that it becomes clear for all of you. So this is the example here, just pay attention. A buys a truck from B. From the first line itself, just understand three things. One person is buyer, one person is seller, and again you have to identify what are goods. So who is buyer, who is seller, and what are goods? Let me have that in the chat box from all of you. In this example, who is buyer, who is seller, and what are the goods? A is buyer, correct Vishnu? B is seller, correct? And tractor is movable goods, so it falls into the definition of goods. It's a movable property, right? So obviously, when one person is selling goods to another, obviously Sale of Goods Act will be applicable. Correct, Dakshita? So let me read this further. Later it is discovered. So he has already sold the truck or tractor basically to A. Okay, B has already sold it to A. Later it is discovered that B had no title. So even if B has sold something which was lying with him, he had no title. Maybe this belonged to his friend or his any relative or his father, or maybe it was stolen. We don't know. So it is just mentioned that later on it was discovered that B had no title. So in that case, what is the duty of A? A must return it to the true owner. Who is the true owner? Who is the actual owner of the goods? So maybe police complaint is filed and then police came on searching and then they found this tractor with A. So when they found this tractor with A, obviously police will take back these goods and it will give it to the actual owner. And then what is because A will say that there is no fault of mine. How am I supposed to bear the loss? So he will recover his loss from B. So from the seller, he will recover whatever payment he has made, he will recover that. And also if any damages have happened, he can recover that also from B. So that is what it is mentioned. So first of all, A has to return these goods to the true owner. He cannot say that I have made the full payment. It is my tractor now. I will not give it to you. He cannot say that because goods belong to the person who has the title. So the true title was with some other person. So he has to give these goods to, or he has to give this tractor to the actual owner. He cannot deny the fact, but what he can do is he can recover the amount, whatever he has paid from B, that is the seller. So here it is mentioned that he may sue B to recover for the purchase price. Why he has to file a suit? Because it may happen that the seller is not ready to pay him on directly. So it's not easy to get the money recovered from any person. So obviously the court case is filed, and then if you succeed, you can get the amount back. So that is what it is mentioned here. Are we clear till this point? Are we clear till this point? What are the rights of buyer and how does it go? So in case of stolen goods or where the person is not the owner and he is still selling the goods, which condition is applied? Which condition is applied? It is implied condition as to title. What is the relevance of this point? When does the seller should have the right? So because as we know, in the case of sale, there is immediate transfer of ownership. In the case of sale, there is immediate transfer of ownership. So in that case, seller should have the ownership right then and there. In case of agreement to sell, what happens is that on a future date, ownership rights will transfer. So law has given that time period, that buffer time to the seller, saying that even though at the time of agreement to sell, you do not have the right, maybe on the date when the agreement was signed, but when you are actually selling it, that means when the agreement to sale is converting into sale, at that time you should have this right. So let me take a quick example for this agreement to sell also. It's not written here. You have to just listen to me to understand this. Suppose Samarth has a beautiful farmhouse. Okay, it does not belong to him. It belongs to his grandfather. Let me just make Samarth also, feel good about it, that he, the owner, or maybe he will. So for the time being, there is a friend of Samarth who says that I want to have some, business, and I want some kind of farmhouse wherein I can grow crops and I can sell it to people. And nowadays there are many startup ideas going on with that project. So I want to have your farmhouse. If you are ready to sell, I am ready to, purchase that. So Samarth has had a quick chat with his friend and he is ready to sell this off to the other person. So the other person is not aware whether Samarth himself is the owner or his grandfather is owner. So on records, basically, his grandfather is the owner, but Samarth is showing to his friend that ye mera hi to hai. This farmhouse belongs to me only. So he has, get into this agreement to sell, that I will sell it to you after 6 months. Not now. I will not sell it to you right now. I will sell it to you after 6 months, because he thinks that he needs at least 6 months to convince his grandfather. So only when his grandfather is convinced, this ownership will be transferred. So if suppose at the end of 6 months, his grandfather does not, permit him to sell the farmhouse, in that case, this contract will come to an end. So obviously, if any payment has been made by his friend, Samarth will have to return that. And this farmhouse will still belong to the grandfather only. But suppose grandfather allows him to sell, then in that case, Samarth becomes the owner, and then he can pass on his ownership rights to other person, that is his friend. Okay. Let me just take the final conclusion here. There is one more example given here. A sells tins of condensed milk labeled CDF brand to B. So till this point, are we understanding that A is the seller, B is the buyer, and what is the goods here? What is the subject matter? It is condensed milk, and this condensed milk is of a particular brand, that is CDF brand. So this is branded goods. So wherever there is a particular brand, we call it branded goods. Okay. But the sale infringes another party's trademark rights. So what does it say? That this condensed milk had a particular label of CDF brand, but this brand is not registered with that name. They are, whosoever has manufactured this condensed milk, they have used the trademark of any other person. So normally there is a different act altogether for the intellectual property rights, and it says that no one can use your intellectual property right. If you have registered it in your name, the other person cannot use that. So if I have some trademark, like ICAI has a logo, right? You cannot use it anywhere and at any place. So only ICAI has the right to use that. So that is the trademark or the symbol or the logo which you have. So that is a brand created kind of. So that is something, if anyone else is using, obviously they are infringing or they are disturbing the others, right? And they are creating, a wrong or they are creating a misconception in the minds of others that this is a very good brand, though it does not have any value or it does not belong to the actual person with whom we are referring to. So what is the legal principle here? The seller has no lawful rights to sell the goods in the manner represented. So even though the seller is selling the goods, but since he is not the owner of that particular uh, commodity, since he is using this trademark does not belongs to him. That is what is meant here. So what is the result? This also amounts to breach of the implied condition as to title or right to sell, because this CDF brand can be used only by the person who have this name registered with them. Any other person cannot use the same name. So if at any point of time someone is using, by they are doing this kind of fraud, they are using someone else's name to sell their goods. In that case, also this condition will apply. So ultimately, what will be the result? As a buyer, you will have to, reject the goods, you will have to repudiate the contract, and you can claim your money back. Whatever price you have paid, you can claim that back. And also you can claim some damages also if you have suffered any. Okay, let me move further. So Vishnu is asking, ma'am, but an example of Samarth farmhouse isn't, yes, it is immovable property. I was just trying to tell you the whole topic. Okay, at least you found out that this is in this case, the Sale of Goods Act will not be applicable. That is very perfectly mentioned here, Vishnu. So I was just telling you just to make you understand that this can happen in such a way. Okay, so ownership thing, just to explain that, I was taking that example. You can take it with any other kind of movable property also. But that was easier to make you understand. So I took that. Next, condition as to description. Section 15. Goods must correspond with description. So whatever the seller has described, suppose seller has mentioned about, while selling, the seller is saying that this is a very good product. If you apply it on your face, it will glow and whatever he's saying. So it must correspond with the description whatever seller has given. Because as a buyer, I don't have any idea what to purchase and what not to purchase. And if I'm relying on seller, whatever he has described, the goods must correspond accordingly. And if they are not, obviously I can repudiate the contract, I can claim the damages and the things like that. So let me just read it. What is given in section 15. There is a contract for sale of the goods by description. There is an implied condition that the goods shall correspond with the description. And if the sale is by sample as well as description, it is not sufficient that the bulk of the goods correspond with the sample if the goods do not also correspond with the description. So though it might seem that it is a very long sentence, we can just split it into two parts. Section 15 talks about two things. So if goods are sold by description, this condition is applicable. Again, it says the second part. The second part relates to when goods are sold by description and sample. So both the things are mentioned in one section itself, but we have split it into two to understand better. So in this slide, we are understanding what do you mean by condition as to description. And other slide, we will discuss the second part. Okay, so let us concentrate on the first part now. So let us understand the concept behind this. The buyer is not bound to accept the goods that do not match the description. If you contract to sell peas, that means if seller has if the seller and buyer have contracted to sell or purchase peas, you cannot compel the buyer to take these. So whatever is described, if you have described peas, you have to sell peas only. You cannot sell some other commodity in the name of something else. So the description is essential for identifying the goods. Breach will entitle the rejection. So the buyer has the right to reject the goods. Okay. So if something is sold in, by describing the object that this is what it is, and ultimately when you are using it, you do not find it in the same manner, then you have the right to reject it. So there is one more example, practical example. If you see here, A orders Egyptian cotton from B. So there is a particular variety of cotton which is known as Egyptian cotton. Let us assume that B supplies mixed cotton instead. So though A here is buyer, so A had ordered Egyptian cotton from B. However, B has supplied him some other kind of cotton, which is mixed cotton. So A has all the right to reject the goods. So since you have to understand why he is rejecting the goods. So till now, at least we must understand that if we are not satisfied with the goods, we can return it. But at this point of time, being law students, now you should understand for what reason we are returning the goods, which section shall apply. So are we returning the goods because of the reason that the seller is not having the title? No, that is not the case. B is the owner of the goods, but he is supplying something else. He is not supplying as per the description. This description could be given by the buyer, could be given by the seller. So if the goods are not supplied as per the description, then the buyer has the right to reject those goods. So in that case, so here it is mentioned, if you contract to sell peas and you cannot sell beans, so that is a quote which they have used here, that whatever is described only, you have to sell that. You cannot sell something else. Okay. So for the quick revision, basically, the case law name is also mentioned here if you want to check it further. But the main point is the quick revision tab, which is given here. Goods must correspond with the description. Sale by sample we will study in the next part and not here. Here mainly the buyer will have the right to reject the goods and claim his money back. Next, implied condition in sale by sample. So suppose you are shown some sample by the seller, and on the basis of that sample, you have ordered say 50 pieces of that particular thing or 100 pieces of that particular thing. Then in that case, whatever the bulk order you will receive, it should match with the sample which was earlier shown to you. And if it does not correspond to that, if it does not matches with that, you will have to return. You have the right to return the entire lot. You are not supposed to, have that particular thing. So that is what is mentioned here. Because the seller will say, you had ordered everything. Why should I return it now? I mean, why should I give you the money back? I have already spent so much time and energy in, preparing or making these goods for you. And now you are returning. So you can obviously apply this implied condition and say that the sample you showed me was different. The finished goods are different now. So since these two are not matching, I can simply return the goods. This is mentioned in section 17. So you can take this help of section 17 while returning the goods. So like again, in the last session also, I took this example that while in the weddings normally or in any of the birthday parties or things like that, nowadays what happens is you order a variety of gift items on the basis of some sample items which are shown maybe online, or you physically you are going somewhere and you are seeing that, okay, this looks good, like this chocolate box here, it looks very fancy and it is very nice, and it shows that it has variety of products. So around 2, 3 or 5 or 6 items are there in this whole box. So in the sample they have shown that around 6 or 7 items are there, but when you finally get the finished product, when you finally get the bulk and you open the box, you see that only 5 items are there. So they showed you 7 items earlier in the sample, but ultimately they are giving you 5. You are paying the full price, but you are receiving less. So why will I accept that? So I have all the right, being the buyer, I have all the right to reject the entire lot based on this implied condition that good should correspond with the sample. Whatever is shown to me should be supplied to me. So I should not be cheated. That is what is mentioned here. The bulk shall correspond with the sample in quality. So in quality also it should match. It is not just the quantity. It should match with the quality also. Buyer shall have the reasonable opportunity of comparing the bulk with the sample. So it should not be that the seller is not giving him the sample to compare. Buyer has all the right to compare, to make the comparison between the sample showed to him and the final product which he is receiving. Goods shall be free from the latent defects, rendering them unmerchantable. So what do you mean by this latent defects? So if you want to just note it down here, you can do so. There are two terms which will be used 2-3 times in this whole unit. One is patent defect and the other is latent defect. Okay. One is patent defect and the other is latent defect. Let me just tell you what is the meaning of both. So patent defect broadly exists. You can easily identify, you understand what is defect, right? So if you are purchasing the book, and if you see a hole there, or if it is torn, the first page, the cover page itself is torn, that is a defect in the book. You will not accept that. You will ask the shopkeeper to show some other book. Instead of this torn one, you want some other book to be given. So patent defect is a defect which is seen or which is visible at the time of sale. So any defect which is visible, which is clearly visible when you are looking at the goods, that is known as patent defect. For this patent defect, if it is visible and if you are still purchasing the goods, who is responsible? So what we can write here is who is responsible? Buyer will be responsible, because even after seeing he's buying the goods, it is not the seller's fault. It is the fault of the buyer. So buyer will be responsible. Okay. If we talk about the latent defect is something which is not visible by the naked eyes. Simply meaning देखने से पता नहीं चल रहा कि कोई defect है. But when later on you will see, you will find that there is a defect. So suppose I purchased a law book. So while checking it, how do you check any book? So you actually check the pages, like, okay, it has, pages like this. You check the pages like this. If anything, if the book is torn or any of the pages is torn, you can understand, you can check, and you can just purchase it. So whether it is latest edition or not, you can check that. So that all that is patent. So everything which is visible is any kind of thing which is visible, and if there is any defect, it is known as patent defect. Something which is not visible then and there. So something which is later on identified. Later on, some thing is identified, or the defect which is visible later on. So defect which is visible later on. So I'm just writing visible later. Okay. So if any defect is visible later on, so in that case, who will be responsible? So what kind of defect could be there which is not, identified then and there, and it is checked later? Any idea what kind of defect could be there which is which you have found out later on and not on the shop itself? Has anyone experienced anything like that? It might happen that you might have also experienced something. Who has written technical defect? What is this technical? Technical kind of thing is what? Okay, let me give you an easy example to understand. So when you are reading the book, one chapter itself is missing, or maybe 1 or 2 pages are missing. So obviously this will not come to your eyes, or you will not be able to see it while checking at the shop. When you are actually reading it, you are finding that some pages are missing. After page number 23 or 24, 2-3 pages are missing. And then again, you have a different chapter. So that kind of defect wherein some pages are missing or a complete chapter is missing, what you can do, can you return the goods? Can shopkeeper say, आपको दिखाया तो था, आपने उस टाइम क्यों नहीं देखा? अब तो मैं वापस नहीं लूंगा आपकी book. I will not take the book back now. I showed you the book. You could have checked it then and there. I will not take it later. Can the seller say that? The seller obviously will say that he will not be ready to take the goods back. He will not ready to accept his fault or whatever may be. In that case, it is given in the law that you can return those goods, because here seller is responsible. So whenever seller is responsible, it is the right of the buyer. He can return the goods, he can claim the damages, he can get his money back. And wherever we are saying that buyer is responsible, he cannot return the goods. That is the difference between these two. And why we are studying this? Because here it is clearly mentioned in case of sale by sample, goods should be free from latent defects. So goods should be free from latent defects. Then only if there is a kind of patent defects, the buyer should have given those goods then and there. But that time the defect was not visible. The defect was lying maybe later on also. So therefore, we are studying this part. Let me just again tell this point to you. So what we were discussing, I'll read it from here. In a sale by sample, the following conditions are implied. It is automatically implied that goods shall be free from latent defects. There will not be any latent defects, but if you find any latent defects, you can return the goods. Okay, if you find any latent defects in these goods, then you can return them. Is it clear? Is it clear till here? Yes or no? Sale by sample. Patent defect, latent defect. Are you able to get this point? Okay, thank you, Kuldeep. Okay, Ushri. Fine, fine. So I'll continue with this. Okay. Next. Let me first clear this up. Okay, there are some examples. In a sale by sample of 2 parcels of wheat, the buyer must get a reasonable opportunity to compare the bulk with the sample. So this is just a right which is mentioned here, that the buyer has a right to compare. You will be able to compare only in case of sale by sample. So that is mentioned here. When you are directly taking the goods, obviously you don't have anything else to compare with. So comparison is done only when a sample is shown to you and finally you receive the ordered product. Okay. Next, a company sold shoes by sample. The sole contained paper, a hidden defect which is not discoverable on ordinary inspection, and therefore the buyer has the right to return these goods. Okay, so here in second example, it talks about the latent defect, a defect which is not visible by your naked eyes. There and then you could not check that. Later on, you find it out, and therefore you have the right to return these goods. Okay, buyer could reject the goods. It is mentioned that buyer could reject the goods because they were affected by the latent defect. Okay, patent defect, it is always the responsibility of the buyer. You have to check the goods yourself. If there was a defect and it was easily visible, you could have returned. You should not have taken it. That is the meaning. But in the case of latent defects, the defects which are not visible directly, so in that case, it is assumed that buyer is not responsible. It is the duty of the seller to take the liability, and he has to, make the payment and all. So he will be liable for the damages. Goods can be returned to him. Okay, moving further. Let me clear this out first of all. Okay, sale by sample as well as by description. So again, both the things are mentioned here. It is a combined condition. So when you are selling by sample and at the same time you are describing it also. So both the things should exist. So when the buyer is finally receiving the goods, he will compare with the sample and also he will check whether it corresponds with the description which was given. So if both the things are matching, then only he will accept the goods. Otherwise, he has all the right to reject the goods. Okay. So this is, talking about both the things existing together, sample as well as description. Where the sale is both by sample and description, the goods must correspond with the sample, also with this description. So both the conditions have to be satisfied. If you are not able to satisfy both the conditions, then this will not be applicable. Important rule, it should correspond with sample alone. Obviously, correspondence with the sample alone is not sufficient. Both the conditions have to be there. Then only you can apply this one. For example, oil is sold as refined sunflower oil. It corresponded with the sample. It matched with the sample, but it was mixed with hemp oil. Hence, the buyer could reject it. So why it was rejected? it was matching with the sample. That was one condition that was satisfied, but the description was that it should have only the sunflower oil. However, it was mixed with hemp oil, some other oil also, and therefore it was not matching with the description, and therefore you can reject it. So that is the example here. Any questions? Okay, there is some question in the chat box, but I'll take this up after I finish off this particular topic. Okay. Condition as to quality or fitness. See, this topic is very, very important because case studies can be asked from this part. Okay, so let us understand. First of all, you have to remember this section at least, section 16, subsection 1, or we call it 16.1 directly. So it talks about all kinds of goods except edibles. So because for edibles or eatables, we have separate condition, which is known as condition as to wholesomeness. Therefore, that part is taken differently. With respect to all other kinds of goods, maybe furniture, electronics, or any kind of other gadgets and all, this condition as to quality or fitness will exist. Okay. So generally, there is no implied condition as to quality or fitness. Generally, there is no implied condition. However, but such a condition arises when, first point, when buyer makes known the particular purpose, buyer relies on seller's skill or judgment, seller sells in goods of that description. So if all the three exist, then only this condition will apply. Okay. So suppose it may happen that you have gone to a particular shop which regularly deals with those kind of goods. So suppose I have gone to a mobile seller. So a person who sells mobile regularly, he sells mobile. So that is again very important. The seller usually deals in those goods. So it should not be that he is dealing only once or twice, or maybe he's not a regular dealer. So if you are choosing the wrong person, then it is your fault. But if you are choosing the person who is in regular dealing of such goods, then you can go to him, and again this condition can be applied. But again, you have to fulfill the other two conditions also. So I'm starting with the last point first. So let me give you the example again. So I went to a shopkeeper, or I went to a shop which regularly deals in mobile. So basically, their hoarding suggested that it is a mobile seller, wholesaler, mobile retailer shop. Okay. So I went to that shop. I explained him my purpose because I was okay to purchase any kind of mobile. I did not have any fixed mindset that I have to purchase only the Galaxy, the Samsung phone, or any kind of Apple phone. I was okay with any of the phones, but I had specified him that I am a chartered accountant. I will have lot many documents in my storage, or my WhatsApp or my mail account. So I need to have good storage. I will be running many applications at the same time. So again, I need to have a very good, strong memory to have all the tasks done together. The phone should not hang. Basically, it should have very good camera. So I suggested the purpose, or I mentioned the particular purpose for which I am purchasing. Or maybe if suppose I am a photographer, and in that case I have explained it to the shopkeeper that I need a phone for which I will be using in my photography, or when I will be making reels, I'll be using that particular phone. So then if the mobile seller, whosoever is there, he is telling me from his own expertise that this particular mobile will be fit for you. This will be suitable for your purpose, whatever you have told me. Accordingly, this is the best one for you. You should not think of any other, but you should just purchase this one. So he has suggested one from his side. So if all these 3 points are existing, so first point was I went to a shop which regularly deals in those kind of goods. Second, when I have told my particular purpose to the other person. And the third is I'm relying on his skill or judgment. I'm saying that, okay, I am not able to understand it better because I am not that techno-savvy person. I don't understand this technical terms, whatever you are using. You are the better person to understand. I have told you my purpose, why I need this phone. So suppose a person who regularly play games, so he need to have a very good, phone for that particular thing. So again, different kinds of models are available for different variety of goods. So being a layman, being an ordinary person, we might not be aware of what all technology is existing. So we are relying on the seller who is selling us those kind of goods, and he is a better person to understand. भैया जो आपको ठीक लगे वो मुझे दे दो, अच्छा चलना चाहिए बस, तो मेरा काम हो जाए, इस तरीके से आपने उसे बोला. Now the shopkeeper is giving you one of the selected phones which you might be using for your purpose. So you took that phone home and then you started using it, and then you understood that this is not working well. Can you return the goods? Saying that, saying that आपने बोला था ये काम करेगा लेकिन ये तो नहीं कर रहा. This phone is not working for me. I told you my purpose, but it is not working in that way. Because the seller will say, why should I return these goods? These goods are not defective. Okay, I have given you the best phone which I could give. You could have also checked it then and there whether it is working or not, but you did not check it. It is not my fault. The seller will say like that. So will the seller be bound to accept the goods back, or can he be made liable to take the goods back and refund the money? Can he be made liable and refund the money? So if you you are able to prove all these 3 points, then in that case this condition will be applicable. This condition says that it is the goods which you are using should be fit for use, fit for consumption. So good will be fit for consumption, and if they are not fit for the particular purpose for which you have purchased them, then you have all the right to return the goods. You can claim the money back. So all these 3 points have to be there. If any of the point is missing, then it will not be applicable. Are you clear till here? Are you all clear till here? Because there is an exception to it. We will discuss the exception. What is the exception? Can anyone tell me here? For this second point, there is an exception. For this second point, there may be an exception. Suppose I have told my purpose that I need the phone for this reason. And then I have also told them that I need only Xiaomi's phone or Redmi, basically, that I need this model only. I have told them I need this model only. Though I have told them my purpose, shopkeeper is saying this will not be good for you. You should have taken, maybe OnePlus or some other phone. But I am rejecting his skill or judgment. I am relying on my skill and judgment. Being the buyer, I am relying on my skill and judgment. I am not listening to what shopkeeper is telling me. And then later on, when I'm using the phone, like suppose I purchase that Redmi or Xiaomi phone and I'm using that, and then later on, I realize that yes, the shopkeeper was right. I should not have purchased this. I should have taken the other one. So let me just go back to the shop and exchange the phone. Just take this back and give me the other one. Will the shopkeeper be bound to take the goods back in that particular case? Will he be bound? Will he be bound to take the goods? No, because what the shopkeeper will say? Shri Vishnu, you all have given the correct answer, but what will be the excuse given by the shopkeeper? Shopkeepers will say that these goods you have only suggested for yourself. I did not tell it to you. Whatever you asked, I have given it to you. There is no fault of mine. So you are not relying on my skill or judgment. You are relying on your own. So in that case, you cannot return the goods. So therefore, we are saying that if you are asking any patented goods or any branded goods, then in that case, this condition as to quality or fitness is not applicable. So if the goods are taken in any branded name or any patented goods you have taken, then in that case, this condition will not be applicable because you have applied your own skill and judgment to purchase those particular goods. Okay, so if these conditions are satisfied, goods must be reasonably fit for that purpose. It is mentioned here. And then one more, term is used here: single purpose goods. What are single purpose goods? What are multi-purpose goods? Can anyone tell me? It's very simple. Single purpose goods. Goods which can be used for a single purpose only. Suppose you purchase noodles. what will it be used for? Suppose you purchase noodles, what will it be used for? You purchased shoes, what will that be used for? Yeah. So Vishnu and Kuldeep, they are saying noodles will be used for eating only, right? So we need not to tell the purpose. When we are asking the shopkeeper to give us a good noodles, I want, whatever a new variety of noodle has come or what kind of noodles are available, just give me a good set of new noodles. I want that. So if you are relying on the skill and judgment of the seller, he has given you a particular thing, then you can obviously take those goods. So here it is saying that it is meant or it is clearly defined here that if the goods are single purpose only, you need not to tell your particular purpose. The first point. When the buyer, here it is mentioned that buyer should make his particular purpose known to the seller. But if the goods are only for one single purpose only, then in that case, that purpose, even if he has not mentioned, then also this condition shall be applicable. Okay. But if the good can be used for multi-purpose. Okay, the goods can be used in variety of ways. So any example where this multi-purpose goods are there? What is multi-purpose goods? Any example? Phone, electricity, yes, phone can be used multi-purpose, correct. So if you are just saying that I need a phone, obviously the other guy will ask you different questions, whether you will use it for, clicking photographs or you want to work on it or you just want to chat or why you are using that. So mobile obviously is a multi-purpose. You can say that. Milk is obviously multi-purpose, very nice, Gangula. Laptop is again multi-purpose because you see if you are a designer you will use it in a different way. If you are a professional, I mean CA or CS, we will use it in a different way. So the speed matters, and whatever softwares we are using, that is again different, and the configuration of the laptop will be different in all those cases. Okay, so as per the requirement of a person, different things can be made available by the shopkeeper. So therefore the purpose is very important, that you have to make your purpose known to the seller at the time of getting into the transaction. So if you want to actually apply this condition, you have to tell the seller. But if the goods are used only for a single purpose, you need not to tell the seller cannot say that you did not tell me the purpose for this goods, because there is only one purpose. If the goods can be used for multi-purpose, then in that case, telling the purpose is very important. So that is what is mentioned here. So for the first point also, we have some kind of exception. The second point also, we have some kind of exception. Okay. Okay, so let us see this example and let me quickly know who is the buyer, who is the seller, and what is the subject matter here. That is, what do you mean by goods here? What is falling into the category of goods? A buys a set of false teeth from B, a dentist. And that set of teeth is not fitting into A's mouth. Who is buyer? Who is seller? What are goods? What is happening? Who has given the correct answer? Let me see. Ushri saying A is buyer, seller is B, and goods are the false teeth. Correct. Samarth is also mentioning the same. Bhumik is mentioning the same. Then Dakshita has mentioned B is seller. Okay, correct. So you are now aware who is buyer, who is seller, what are goods. So can you just imagine this false teeth are also goods? So normally dentist is a professional. He provides his services. But when he's selling false teeth, that becomes goods. So Sales of Good Act will be applicable on that. So he's, providing two things. He's giving his services also, and he is fixing the teeth also. Likewise, when you are, giving your bike on service, what happens is you are giving your bike or anything on service. What happens? Some oil is refilled, or maybe some cleaning part is done, or some other services are done. So for the service they will charge service charge, but if they have changed oil, or if they have changed the lights, or if they have changed the brakes or something, they will charge for the goods. So at that point of time, they have given two things to you. I mean, they have provided two kinds of things to you. One is they have provided services, and at the same time they have supplied goods also. So sale of goods act will be applicable there. Similarly here, sale of goods act will be applicable even though dentist is a service provider. Normally he's a professional. Okay. And if the teeth, I mean, buyer is paying, the client is paying very much, and it costs a lot, false teeth nowadays. So if he is paying and that teeth is not fitting into the mouth, can the dentist say that it is not my fault? uh, Probably whatever has happened, I am not responsible for that and all that. So normally these type of, can you purchase false teeth from anywhere in the market? Can you purchase it anywhere in the market and you can just fix it for yourself? Can you do that? Of course not. We cannot do so. So firstly, when we have to apply any kind of condition, we want to return these false teeth, right? Because this is not fitting into us. So for what reason we are returning, let us understand. We are returning it for the reason of that it is not fit for use. It is not fit for use. When you are saying it is not fit for use, is it eatable? No, it is not eatable. It is something different. So it is something different. So for quality and fitness, we have section 16(1). So for satisfying this category of section 16(1), we have to satisfy these three conditions. So again, you have to check whether the person from whom you are purchasing, that means the seller here is dentist. So whether the seller usually deals in those goods, yes, seller usually. So here dentist usually deals in this false teeth category. There is no one else. We are going to the right person. He deals in this kind of goods. So did you make your purpose known to him? Yes, we told him that we want the complete set, and he has taken our measurement also, and he has done everything. And we have just told him, because we don't know how to get the things, or which I mean material should be used for creating this false teeth and all. We are not the right person. We are relying on his skill and judgment. Whatever he has decided for us, that is best. So we are relying on him. We have told him his particular purpose, and obviously we have gone to the right person. And therefore, if this is not fitting to you, if this is not fit for use, then you can return these goods. You can claim the damages also. So that is what you have to justify while returning the goods. That is what is meant here. Okay. So here, since it is not fitting, it is resulting into breach. There is one case here. We discussed this case last in the last session also. That is Priest versus Last. This is the name of the case, and it is a hot water bottle case. I don't know how many of you have seen this kind of hot water bottle. Let me know in the chat box if you have seen this kind of hot water bottle. It used to exist earlier. Nowadays we have electric ones. Okay, Vishnu has seen this. Ushri has also seen this. So you can imagine what might have happened. So we used to fill, or the earlier people used to fill hot water in this bag. And with this, they used to apply it wherever they used to have pain in the body. They used to use it for this massage purpose, for getting relief of the pain. Exactly, Dyutimon. So that is what is mentioned here. So this person, this lady, has gone to a chemist shop and she has purchased this hot water bag. She is relying on this chemist because she has mentioned that I need a kind of hot water bag, whatever best option available with you, just give it to me. So let me just read it for you so that it will be, really funny for you all to understand. Mr. Priest, so it is the name of the shopkeeper or the chemist. Mr. Priest, Mr. Priest, let us quickly make out who is Mrs. Priest. Is Mrs. Priest? This is the lady. Mrs. Priest is suffering from rheumatism, and she went to chemist Mr. Last. So chemist name is Mr. Last, and he's the seller, to buy a hot water bottle. So this lady has gone to this person to buy a hot water bottle. So whether she has gone to correct place or not, that is what you have to make out. So she has went to a chemist shop to purchase this hot water bottle, and which is a correct place. You are not purchasing it from any ordinary provisional store. You are purchasing it from the right medical store. So that has to be correct. So the buyer was right in her approach. So she clearly mentioned that I need a hot water bottle for this particular purpose. And this shopkeeper told him, or this chemist told him, that this is the best thing which I can give to you. But when she poured the water into it, it actually burst off. So the whole water spilled over her. And because there was some defect, and it is clearly mentioned that there was a latent defect in the bottle, which was not visible when you are purchasing. Only when you fill the water into it, you will find that it will explode. So it had happened that way. She got some burns, and her skin was damaged or something like that. She went to the shopkeeper, she went to this chemist again to claim the money back, to claim the damages, but he refused. Then she went to the court to settle the matter, and therefore the court here said that. So let us hear what this lady said and what this chemist said. The lady said that I relied on his skill. The bottle was not fit for the particular purpose he has sold me. However, the shopkeeper is saying that I never expressed any warranty that it will be, fit for use. So even if he has not expressly said anything, it is given in the law and you have the right to return it. So that is what we will be studying here. So ultimately, finally, the lady got the relief. She got the damages from the court. The court actually ordered in her favor, and the other person had to return the money as well as some damages also to her. So that is how this whole actually takes place. So we need to understand how these things are practically done in the real world. Next, let us take some more examples. Goods purchased under patent or brand name. Okay, let me just quickly ask you about this illustration. A goes to B's shop and asks for a merit swing machine. Let us, whenever this kind of questions are given to you, first identify who is buyer, who is seller, and what are the goods. Let us quickly have the answers from you. A is buyer, B is seller. Gitanoy, you are very quick in replying. Okay, Bhumik has also replied, and then Harshit has also correct. Swing machine are the goods. And again, if you clearly see here that she or he, whosoever it is, they are asking for a branded goods. Merit swing machine. Maybe it is one kind of brand. They want this particular swing machine. So this is branded goods. So in this case, whether if this machine does not turn out to be fit for use, then can she return this, or can this person return this? Why? What is the reason? Because you are not relying on the skill and judgment of the seller. You are relying on your own skill and judgment, because you are purchasing the branded goods. You are purchasing the patented goods. You already came with a particular mindset that I want to purchase this only. I don't want any other explanation, or I don't want to see any other goods. So where the buyer asks for a specific brand or trade name, it may indicate that the buyer is relying on his own choice rather than the seller's skill. So what is the ultimate effect? Even if the machine turns out of bad quality or it is not fit for use, the usual implied condition as to fitness may not apply here in the same way as we are talking. Next, condition as to merchantable quality. Condition as to merchantable quality, it simply means that the goods should be sellable normally as they are known in the market. But let us read it full so as to better understand. This is contained in section 16, subsection 2. So where the goods are bought by description from a seller dealing in such goods, there is an implied condition that goods shall be of merchantable quality. When you are going to a person who regularly deals in those goods, you think that these goods will be of regular or normal quality. At least it should have a basic thing, whatever is described by the seller. So these are saleable, or these are actually having good quality goods. What is the meaning? So goods must be saleable. Saleable means they are regularly being sold in the market with the same name, whatever name. Suppose we are asking for noodles, then whatever goods are supplied to us are known as noodles in the market. It is not something else. If we are going to purchase toothbrush, obviously that toothbrush should be known in the name of toothbrush only, and the purpose for which it is used and everything. So goods must be saleable in the name in which they are known in the market, basically. Next, goods must be reasonably fit for the ordinary purpose for which such goods are used. तो हमने जिस चीज के लिए वो खरीदा है उसमें हम उसको यूज कर पाए. So for whatever purpose we have purchased it for, we can use it for that purpose also. So that is what is meant here. Qualification. If the buyer examines the goods, no implied condition exists for defect which examination ought to have revealed. So again, it talks about your latent defect and patent defect kind of thing. If the buyer examines the goods, if he has found out any defect is existing, in that case, obviously, this condition he can return the goods. But later on, if he finds out anything, that will be a different case altogether. So let me read it again. If the buyer examines the goods, no implied condition exists for the defects which examination ought to have revealed. And there is an example for this, I guess. So let us read the example and then let us understand. If a person orders motor horns and they get damaged by bad packing, the goods are not of mercantile quality. Because whenever if we are ordering something, suppose we order something online and it is not properly packed and sent to us, then obviously we can say that these are not of mercantile quality. Though online it was looking good, but it should reach to me in safe and sound form also in the proper manner. So though I have not mentioned how the packing should be done, the other side, the seller is aware how the packing is to be done so that it generally reaches to the buyer in a safe and sound manner. So if it is not being done that way, we can return the goods saying that these goods are not of mercantile quality. Okay. Like there is one more example. A buys a black velvet cloth from C. So A is the buyer. He is buying this black color velvet cloth from C. The cloth is damaged by ants. So when you are purchasing the cloth, those ants were not visible, or the holes which were made by the ants, that was not clearly visible at the shop. But when you have, when you tried to use that cloth, because normally the uh, cloth which is folded, suppose you are not able to see each and everything at each and every corner. But when you open the cloth at home, maybe, and you try to cut it for a particular measurement, at that point of time you saw that there is a damage caused by ant here. This is damaged piece. So you return this back to the seller. So here it is mentioned that yes, you can return it to the seller, because whatever goods have been sold to you should be of a proper quality, should be of basically reasonable quality, or it should be saleable in the form in which it is known. As you have mentioned, it is to be it is supposed to be done by that name also. So these are the two things which you should remember here. Goods should be bought by description. Firstly, you have described what kind of good you want, and the seller should be a regular dealer in those goods. So I think these two things are similar with the condition which you have read earlier also. But one thing is missing here. What is one thing which is missing? If I go back to the earlier slide, 16.1. Let me go back to the earlier slide and tell you. 16.1 basically said that you have told the seller deals in those kind of goods. You have told the particular purpose, relying on the skill and judgment. This particular thing is mentioned in quality or fitness. However, in this mercantile quality, this part is so this is not there. However, the other two things are there. So if you are going to a regular dealer and if you are buying the goods by giving the description that I need this kind of goods, irrespective of any skill and judgment, nothing is mentioned about this. And if the goods turn out to be of bad quality or something, you can return those goods. It is as simple as that. Okay. Next, condition as to wholesomeness. So again and again, this wholesomeness applies only to the eatables, edible things. In contracts involving food and provision, there is an implied condition that goods shall be wholesome, fit for human consumption. Let us read this example. A supplied milk to F. So A is the supplier, means A is the seller, milk are the goods, and F is the buyer. Okay. The milk contained typhoid germs. You cannot check the milk having, when a milk is supplied to you in a packet or something. from the dairy when you are purchasing milk, obviously you cannot check whether it contains any kind of germs then and there. Then you will consume it, or anyone else who has come. I mean, suppose F has consumed, or any of the person. So here it is mentioned F's wife has consumed the milk, and then she was infected, and she ultimately died because of that. So there, here it was mentioned that this is a kind of breach of condition as to fitness. The goods which the supplier is selling, they are not fit for consumption. And at that point itself, we could not check whether any kind of germs exist or not. So obviously, it is actually the duty of the seller to sell goods which are, having good quality, which are fit to be consumed. So that is what is mentioned here. Though the lady died, you cannot compensate someone with the life of a person. But again, this was an example. This was a real, actually, this is a real example. So in this case, it was actually decided that strict action can be taken against the sellers who are not, not selling goods of good quality, or who are selling the eatables having, bad quality. Nowadays also, you can see that there are various, if you have heard of food department, FSSAI, if you eat any kind of chocolate or any chips, behind the packet, I mean on the wrapper itself, you will find FSSAI license number and everything is there. So there is very strict action taken by the food department if you are not selling good quality goods. Still, obviously, there are some adulteration and all, but that is, part and parcel of each and everything. But yes, there are some actions going on, and this is one of the case wherein damages was supposed to be paid by the seller, and also the price, obviously, whatever has been incurred. Okay. So this is the actual case, Frost versus Aylesbury Dairy Company. This is breach of the implied condition of the wholesomeness. Is there anything in the, yeah, preservatives, cancerous preservatives are there, obviously. So these kind of things exist, though the department has not, been able to penalize each and everyone, but there are provisions for that. Whenever, government is strict, they can actually take action against people, because ultimately it is the health of the people which is affected while consuming the goods. So we are done with the implied condition so far. If you want, we can have a break of 5 minutes, and then we can continue with the implied warranties and the last topic, which is caveat emptor. Okay, and we have questions also. So we can have a quick break of 5 minutes. Okay, come back with all of your energy after 5 minutes. So 3:17, we have to be back. Yeah, okay. I can see a few questions in the chat box. Let me just answer that. Someone has asked about that swing machine example. Can we claim the compensation from the brand, the merit swing machine as we were talking about? Let me see who has asked. So, Ruchi, you have asked that question, right? So, Ruchi, yes, of course, we can claim the compensation from the original manufacturer. We can file a suit against that person, the merit company, whatever is there. But from the seller, we cannot, we cannot file a suit against the seller because it was not his fault. So if you have heard about the Cadbury chocolate, uh, there was a time when it was found that there are germs in the Cadbury chocolate. How many of you are aware about this? In the Cadbury dairy milk, it was found that there are some germs or, yeah. So they changed the ads and the campaign, they changed everything. The packing of the chocolate was also changed. And earlier, I mean, now if you go to any shop wherein uh, these Cadbury chocolates are kept in a proper refrigerator, which is given by the Cadbury company. Earlier, that kind of thing was not there. So after some case was filed on that company that some germs are existing in that, in case of Maggie also, correct? So likewise, I mean, sometime or the other in MDH masala or something recently, it was in the news that there are some uh, uh, some chemicals or some unhygienic things are there in the product. So it happens that way. You cannot blame the seller for that because he's selling some branded goods and you are asking for those branded goods, but you can file a complaint against the owners or the actual manufacturers. You can file a complaint against that. That is correct. And I think Vishnu has asked one very, very good question, that in few of the conditions, in few of the implied conditions, like in wholesomeness and all, we do not have a section number. Then why is it called implied? Because it has to be implied by law. So normally, whatever is given in the act, it has to have a section accordingly. So in few of the things we will find sections, but the law also, plays a vital role here, because there are many judgments. Because of the judgments, there is a ruling that this will prevail, even though it is not mentioned in the act, but uh, it will prevail because of this particular judgment. So, priest versus last, or this kind of the dairy company judgment, it actually had so much weight, it actually had so much potential that even though it was not mentioned in the act, that that order was passed in the benefit of the society as a whole, and therefore it has been taken as an implied condition. So that way the act or the law evolves itself. Whatever is drafted, since this is drafted way back in 1930, so after 1930, a lot of things might have changed over the period. So if any kind of change has to happen, that is known as amendment. Whatever changes are happening, and if they are noted down in the act, that is known as amendment. You will find that section separately in the act. But sometimes it also happens that the amendments are not done, but the contention of law is like, you can refer to the case laws also, what was discussed in that particular case law, and similarly, that kind of thing can be applicable, can be made applicable to your case, and then you can ask for the remedy. So that is why these are learned and understood in that way. Okay. So next, let us talk about these implied warranties. So the first warranty is warranty as to undisturbed or quiet possession. So suppose I have purchased this mobile, I have the right to use this mobile wherever and howsoever I want to. No one can come to me and claim that you are not the owner of this phone. There is someone else who is the owner. You will have to return it to someone else. So basically, it is linked with the condition as to title. So when I am purchasing goods as a buyer, I'm talking from the point of view of buyer. If I'm the buyer, I should have the undisturbed or quiet possession. No one should disturb in my right to use. It is my right, being a buyer, it is my right that no one should disturb me. But if at any point of time it happens that there is some other owner which is claiming that these are my goods, then in that case, being the buyer, I have the right to recover damages from whom? From the seller. So since in warranties, the buyer has the right to claim damages, I will have the right to claim damages, even if that was not expressly discussed, it is given in the law that you can claim it. I have not purposely mentioned sections here. There are sections. I have mentioned it in the earlier slides. It's 14B, then we have 14C. So these warranties have their sections. Don't worry about it. Okay. But it is not very much relevant for you to learn each and everything. And if you want to, you can obviously do that. Next is warranty as to non-existence of encumbrances. This topic we discussed yesterday also. Let me just give you the example so that you remember again. Suppose I have purchased a car on loan or on EMI, normally as it is said in the ordinary language. So I have taken a bank loan, I have purchased that car, and now what I'm doing is the loan is still there. It will continue for 5 years. But meanwhile, I want to sell this car to someone else. Can I sell this? So if I'm selling this, obviously I'm not the right person to do so. I should not sell it to someone else because this car is already under some kind of charge. Until and unless I clear the liability which is on this car. What is the liability? I have to clear the loan first, and then only I can use it fully with all the potential. But if I am, I'm not restricting to that, I'm still selling it to someone else, that is not allowed. So I am not fully entitled to do so. And if I am doing so, the buyer has the right to claim damages. Okay, so that is what is written. Whenever there is a buyer, obviously the buyer will not ask whether this car is owned by you or you have taken it on loan. No one will ask these kind of questions, right? So it is presumed that the seller who is selling has the title, the seller who is selling has the complete ownership, the goods are free from any kind of encumbrances. That is what the presumption is. And therefore, that is a right given to the buyer that whenever you come across a situation that there exists some kind of encumbrance in the goods which you have purchased, then you can claim damages from the seller. Is this point clear till here? These two warranties. Next is quality as to fitness or quality or fitness by usage or trade. And the last one is warranty of disclosure of dangerous nature of the goods. So I guess there are details also mentioned and the examples also for you. So we will just quickly check that. I think this one is easy. I will just take the example directly. X buys a laptop from Y. So X is a buyer, Y is a seller, laptop are the goods. Later it is discovered to be stolen property and it is taken away by the true owner. So someone else is saying that he is the owner, Y is not the owner. This is a stolen thing. This laptop was stolen and it has now been sold by the person Y. So what can be the remedy available to X, who is the buyer? So X can now recover the price, whatever he has paid for the laptop, he can recover the price from Y, and also the repair expenses. If he has done any kind of repair on that laptop, he can recover it from Y. So that is what is mentioned here. He can recover this thing. Okay. So this is breach of condition as to title and breach of warranty also. So both the things are applicable in the same example. Let me read out in the chat box if any question. Quiet possession, आसानी से आप उसको use कर सको. Damage to wine, a warranty, because both the things are applicable. There's a breach of condition also, breach of warranty also. What kind of breach of warranty is there? This one, warranty as to undisturbed possession. When I have purchased the laptop, I should be allowed it to use freely. No one should disturb me. No one should bother me for using this. So today I'm using laptop. Tomorrow someone is coming and saying that you cannot use this laptop. This should not happen. So I should not be under a fear that someone will come someday and take this away from me. So if at all anything is happening that way, I can claim damages from the seller. So that is why it is mentioned here. Therefore, this is a case of implied condition as to undisturbed possession. Next, warranty as to non-existence of the encumbrances. So let us directly read this example. A pledges his car with C So let us assume that C is bank here, so that it will be easier for you to understand. So A has pledged his car to the bank or to this person C, and then he sells it to B. So you cannot take advantage of over one thing again and again. Once you have taken loan from someone and now you are selling this also to other person. So that is why it is not allowed. So you do not have complete rights with you, because C, who has given you the loan, he has the right to recover the loan first. And if you are not giving the full amount of the loan, he can sell the car and get the recovery done for himself. So in case of pledge, normally A is not allowed to sell the goods until unless he finally pays off C. Okay, that is the clear cut thing. So even if he's doing so, in that case, B, who is unaware of this whole situation, because B is not aware that this car is a pledged car, or this is already lying on a loan for C. So obviously B will have a right to get the damages from the other party. So that is what is mentioned here. B may compel. So B is actually the buyer now, the new buyer. So he may compel A to clear the loan or pay it himself and recover the amount with the interest. So what is B? B, without disclosing the pledge, so he has sold this car to B. This I think you can very well make out. So if anything which is having some liability, if that is sold to you, in that case, because C has come to B now, he is claiming the full amount of the car, or he is claiming the car actually. He wants the car back. Now B, why will B return the car? Because he has already paid the amount to A. So now he is asking A to pay amount to C, or otherwise pay the complete money back to me, so that everything can be settled. So that is what it is mentioned here. I'm just reading it again for you. Just make sure that you understand it, and if there is any doubt, let me know. A pledges his car with C and then sells it to B without disclosing the pledge. So A is trying to cheat actually. He's not disclosing the full thing, and he has sold the encumbered property, encumbered thing to B. What do you mean by encumbered? Any property, any goods on which charge is created, on which loan is taken, or on which liability is created, basically. So on this car, already a loan was existing. Should not have sold it to someone else, because it is already lying with it is already under pledge. So if A is doing such a kind of thing, what are the rights available to B? So here it is mentioned that B may compel A. Compel means he can force A to clear the loan. So he may ask A to clear the loan. You pay all the amount to C, so that C does not come to me again. Okay, or pay it by himself. Or what B can do, B will pay the amount on his own, and then he has the right to recover it from the other person, that is A, with interest. So it is a kind of indemnity. When you are paying it on behalf of someone else, you are actually getting the recovery of it. That kind of thing can also come into picture here. So this interest portion is basically the damages which you are getting on your thing, whatever has happened. Let me see if you are able to understand. Pledger and pledgee, obviously, pledger and pledgee, you people have the idea of bailment and pledge. So accordingly, you can discuss. So who can recover the amount? Whosoever has paid extra amount. Basically here it is, if B has paid anything over and above the amount of car to, Mr. C or anyone else, then he can recover the damages. That is what is clearly mentioned here. Next. Warranty by usage of trade and dangerous goods. So these are two warranties which we will be discussing in the same slide. So first is warranty as to quality or fitness by usage of trade. So normally whatever we have discussed in the condition of quality and fitness in section 16.1, that was condition, and with the same condition there is an implied warranty also. So you can even claim damages if the goods are not fit for use. If the goods are not fit for use, you can even claim the damages. So trade custom may imply a warranty or condition as to quality or fitness. Disclosure of dangerous nature of the goods. This we all very well understand. If the goods are dangerous and buyer is unaware, seller must warn the buyer of the probable danger. If the seller fails to warn, then the seller may be liable for the damages. So seller should also make the buyer aware, even though it is mentioned on the packet or anything. Being the seller, he has to mention that. Okay. Next topic is caveat emptor. Next topic is caveat emptor. What do you mean by caveat emptor? Let the buyer beware. Let the buyer beware simply means buyer will be responsible. Till now, whatever we have read gives the right to the buyer to claim damages or to recover any kind of damages from the seller. Buyer has the right to reject the goods, buyer has the right to claim the money and everything. So we were talking about the rights of buyer and buyer. Now we are making buyer responsible. That means it is the duty of the buyer to check the goods before he's buying. And if there is any defect or anything, then buyer himself will be responsible. He cannot claim damages or he cannot, return the goods to the seller. So there is a complete opposite topic. Whatever we have read, it is in complete contrast to that. So caveat emptor simply means let the buyer beware. We will study in detail also. Let us first concentrate on the examples. So what you can make out in this examples, let us see. A sells pigs to B. So whether pigs are goods, whether Sales of Goods Act will be applicable. Sale of horses, sale of pigs, whatever it is, you can apply sale of goods. So A sells pigs to B. The pigs are infected and spread diseases. Seller is not automatically liable merely because the buyer has suffered a loss. Buyer must be aware because it was visible when you were doing this kind of transaction. If you are a buyer, you could have seen that the pig is not healthy. The pigs are already infected. And if you are buying those pigs, you cannot make the seller liable saying that you have sold me infected pigs. So the duty lies on the buyer also. At the time of purchase, he should have properly checked, he should have properly, investigated whether the things or whether the pigs he was buying are, healthy and all. So it is not seller to be made responsible for that. He will not pay the damages for this particular thing. That is what is mentioned here. Second example, A buys a horse from B. So A is a buyer, B is seller, and horse are the goods. A buys a horse from B but does not disclose that it is required for riding. So A has bought the horse, but he has not mentioned it. He has not disclosed the particular purpose for what he is purchasing the horse for. The horse is suitable only for drawing a carriage. He cannot, the horse cannot be used for riding purpose. So therefore, it was, since buyer did not disclose all the things or all the facts to the seller, he cannot blame seller for this particular thing that I needed the horse for riding, but you have sold me the other way, because the seller was totally unaware. If you would have told your purpose, in that case, if the seller had given you the wrong horse, he would have been made liable for it. But now when he is totally unaware, you are keeping the facts hidden from him, and now you want damages for the sake of saying that this horse is not suitable for riding, you cannot do so. So law is creating a balance for both seller and buyers. For buyers, a lot of things have been planned so that the seller might not take advantage of the buyer at various point of time. Similarly, there is equal law for the sellers also, so that at every point of time, buyer should not blame sellers and claim damages from them. So there is this kind of law or a provision which exists, which says that it is also the duty of the buyer at the time of purchase that he should purchase with open eyes, open mind, and he should himself check what he is buying. He cannot blame for each and everything on the seller. Okay, let us understand it in detail. What is the meaning? Let the buyer beware. बायर खुद ही जानकार बने, बायर खुद ही समझदार बने, बायर खुद ही अपना ध्यान रखे, ये यहाँ पे इसका मीनिंग है. लेट द बायर बिवेयर, बायर हैज टू बी केयरफुल ऑन हिज ओन व्हेन ही इज परचेजिंग. It means that buyer must make proper selection of the goods. Second, seller is generally not responsible for buyer's bad choice. See, when you are going to purchase when you are going to purchase some t-shirts or maybe jeans, the seller is showing you variety of goods. Whatever he is having, he's showing you all the stuff because he has to sell. So whatever you are picking up, he will say, "Oh, what a nice choice! You have a very nice choice. This color is suiting you, and this is also coming with an offer or something like that," so that you are attracted and you finally purchase it. But you cannot blame everything on the seller because you have to use your own mind also. So that is what is mentioned here. Seller is not bound to disclose all the defects because seller has to sell his goods. Until and unless you ask him and he purposely hides the thing, you cannot blame him. Okay. So seller is not bound to disclose each and every defect. If the buyer relies on his own judgment, seller is generally not liable. So these are the points which you have to be aware of. And you should know that it is not always the fault of the seller. Buyer is also at fault at various point of time. Okay, so this is one part which we have done, and the next topic which we will take up is the exception of this cave attempter. Exception of cave attempter would mean what? Again, who is liable, who is not liable. So if we are talking about the case of cave attempter, buyer is liable. Buyer is liable means he cannot claim damages from the seller. Again, buyer is liable means he cannot claim damages from the seller. He cannot return the goods. He has to take full responsibility. Whatever he has purchased, he has to use those goods. He has to take care of his own goods. I mean, he cannot blame for each and everything on the seller. What are the exceptions to cave attempter? So before understanding the exceptions or before checking what are the exceptions, we must write very important thing here. If we are talking about exceptions to cave attempter, exceptions to cave attempter means who is liable here? Quickly tell me who is liable, buyer or seller? Seller is liable because it is the opposite, or in these circumstances, cave attempter will not apply. What are we studying in this particular topic? Cave attempter will not apply, or these are the exceptional cases where this cave attempter theory is not applicable. These are exceptions to that. Okay, so ultimately seller will be liable. So buyer will not be liable, seller will be liable. So these are the cases. Ultimately, we have, switched to the first topic itself. In the whole conditions and warranties, seller was liable. Then in cave attempter, buyer was liable. Then again, we are saying these are the exceptions to cave attempter, which ultimately means that seller will now be liable. So you can claim damages from the seller. Ultimately, you can claim damages from the seller. This is what is meant here. Okay, let us understand what are the exceptions. There are around 8 exceptions. Let us start with the first one. Okay, this complete portion which you are seeing right now, it is related to one important section which we have already discussed. Can anyone tell me it is related to which section or which topic? Just quickly read this and I think you will be able to make out. Yes, Vishnu has very rightly pointed out. It is, yes, Bhumik is also correct. Section 16.1. What was it related to? Implied condition as to quality and fitness. Correct, correct, correct. So in case of quality and fitness, you cannot blame the buyer. In all cases, wherever there is a breach of quality and fitness, it is always the seller who will be liable, who will be responsible. So this is the condition. Buyer can hold seller liable where he has made his purpose known to the seller, and buyer is relying on the skill and judgment of the seller, and the seller is the usual dealer of those goods. So in that case, buyer will not be responsible, seller will only be responsible. So let us take the example also. An order is placed for trucks to be used for heavy traffic in hilly country. If the trucks are unfit for that particular purpose, seller is liable because you have made known the purpose to the seller. Whatever seller is supplying you, you are relying on his skill and judgment, and he's a regular supplier of those goods. Therefore, if the trucks turn out to be not fit for the purpose for which you have purchased them, that means they cannot be run on in a heavy traffic or in a hilly country, you cannot run them, then in that case, you can return those goods, you can claim the damages. And these are the two cases which are discussed in this particular category. So we have already discussed this priest versus last case, and this timber for railway sleepers, that is a case which you can read it in your module. But the point is clear that buyer can hold seller liable here. Okay, let us discuss the other exceptions also. There are some additional cases wherein you can make seller liable. So first is when goods are sold by description. When goods are sold by description, again, who is liable? Seller is liable because goods should correspond with the description. Buyer cannot be blamed for that. Then the goods are not of mercantile quality because who will assure that the quality is correct? Who will assure that they are delivered in the correct form? They are sellable in the way in which they are done in the market. So who will do all that? Seller. So seller is liable for this purpose also. Then sale is done by sample. Obviously, you cannot blame buyer. It is always the other party to be blamed. So seller is liable for this. Then a sale is by sample and description. Again, the same thing. When usage of trade implies fitness or quality, then seller is guilty of fraud or active concealment. This last point is very important. When seller is guilty of fraud or active concealment, वो लगातार छुपा रहा है. Active concealment is hiding. You are asking again and again whether this is of good quality, whether it is of this material. The seller is hiding the facts from you. He's constantly hiding the fact. He's doing some kind of fraud. So in that case, seller will be held guilty. So in that case, seller can be asked to make the compensation, or he may ask to pay you the damages. So normally, whatever conditions you have read, for all those purposes, caveat emptor will not be applicable. Exceptions to caveat emptor will be the case particularly. So there is a example given here in ready-made garment business. In ready-made garment business, there may be an implied expectation regarding the fit. Whenever you are purchasing any ready-made garment, you obviously try it there in their trial rooms. But if trial rooms are not there, and if you bring that goods home and then you try and then it does not fit, obviously you can return goods. So that is why this trade usage thing is applicable, and here seller is responsible. Seller will take the goods back even if that was not expressly told to them. Okay, so let us move further. Here seller is liable, we have already mentioned. There is one more topic with caveat emptor. There is another topic which is known as caveat venditor. What is caveat venditor? Venditor means vendor, vendor means supplier basically. So then caveat emptor, we are saying let the buyer beware. Caveat venditor means let the seller beware. So seller beware means seller will be responsible. Buyer beware means buyer will be responsible. So again, these two are complete contrast topics in itself, or what we can say exceptions to caveat emptor is generally the caveat venditor. So venditor will be liable or the seller will be responsible in the exceptional cases. So that is the thing. Sometimes this caveat venditor can also be asked in the examination, and therefore we are discussing this topic. So what is the duty in case of caveat emptor or caveat venditor? Let us distinguish these points. So buyer has to do the due diligence. It is the duty of the buyer to fully check the goods before buying them. He has to properly do the examination. In case of caveat venditor, seller has to disclose, seller has to tell each and everything about the goods. It is the duty of the seller that he should reveal if there is any defect in the goods. What is the next point of distinction? In India, we have caveat emptor rule. We have caveat emptor rule. It is a traditional common rule which is there. But nowadays we have shifted to this caveat venditor because we say that consumer is the king. You cannot blame consumers. You cannot blame buyers for purchasing the goods. It is the duty of the seller to sell the goods of proper quality, and it should have all the specifications. It should match with the description and everything. So shift of burden now is on the seller. Okay. Next, in the modern context, we can say that in e-commerce era, buyer has to beware, because you are purchasing online. You are actually checking the goods on your own and you are purchasing that. And if the goods are not of good quality or whatever, sometimes it is mentioned that you can take the refund within 7 days or 10 days, but beyond that you cannot get the refund. So return policies may vary in this particular context. In e-commerce era, you have to be very, very careful. And for if there is still any kind of confusion, you may always go to the consumer forum. If you are not getting any kind of relief in sale of goods app, consumer forum is there to help you out for that. Okay, so let us have the questions for the day, and then we will open up the session. So there is a takeaway from this slide. Keyword enter, which says that the buyer has to beware, is a traditional rule, but nowadays what we are shifting to is the keyword vendetta. That means the duty is of the seller to sell the proper goods, especially in e-commerce era. Okay. So it's quiz time for all of you. Are you all ready to take up the quiz? Yes, Arjun. Keyword tempter means buyer beware, and also keyword vendetta means seller beware. Correct. You are right, Arjun. Yeah. So, okay, let us start with the question. In sale by description, goods must, it's I think very easy. Option is B. It must match description. Correct. Next. In sale by sample, buyer must get discount, or he must get reasonable opportunity to compare, or the ownership, or the warranty card. I think most of you have answered it correctly. Again, the answer is B, reasonable opportunity to compare. Okay. Next, doctrine of keyword emptor means who has to beware? Let the buyer beware. So it's B. Correct. Most of you have already given the answer. Next question, condition as to fitness applies where when buyer relies on. So for quality and fitness condition, option B is correct. Yes, Umek, Harshit, Ikra, all of you have given the correct answer. Harshit. Okay, next. Mercantile quality means goods are. So those of you who want to note down what is the meaning of this mercantile, because it is used again and again, it simply means marketable and usable. Goods are marketable, they are easily sellable in the market, and they are usable also, fit for consumption purpose. Vishnu, which question? Okay, fifth question. Oh, correct. You reminded me. Okay, I'll go back to the slide and then I'll have to ask. But let us start with the theory questions, and then if the time is left, then we will take up that. That was very easy question. I think you will get that very easily. One question was left yesterday, question number 5. So we will take that up, don't worry. But let us see who can answer this one. This is a long case study question. Let me quickly read this for you, and then let's see who can answer. Messrs. Woodworth and Associates, a firm dealing with the wholesale and retail buying and selling of various kinds of wooden logs customized as per the requirement of the customers. They dealt with rosewood, mango wood, teak wood, Burma wood. Oh, there are so many varieties of woods available. So, okay. Mr. Das, a customer, came to the shop and asked for wooden logs measuring 4 inches broad and 8 feet long as required by the carpenter. So he has given his measurements. He wanted the wooden logs to be of this particular measurement. It should be cut in this particular measurement. Mr. Das specifically mentioned that he required the wood which would be best suited for the purpose of making the wooden doors and window frames. So he has mentioned this purpose. The shop owner agreed and arranged the wooden pieces cut into as per the buyer's requirement. So as per the measurement, the cutting was done and it was finally supplied to him. The carpenter visited Mr. Das' house next day, and he found that the seller has supplied mango tree wood, which would most be unsuitable for the purpose. So obviously this will not serve the purpose. That is what the carpenter told him. The carpenter asked Mr. Das to return the wood logs as it would not meet his requirement. The shop owner refused to accept return of the wooden logs on the plea means excuse, that logs were cut to specific requirements of Mr. Das and hence could not be resold. Are you getting this point? What is the shop owner saying? The seller is saying that I am not ready to take this goods back, even though this is of not the quality of wood which you wanted. But since it is cut in a particular measurement, you have to take it because it is of no use to me. So I cannot take this back. It will be a loss to me if I take it back. So here the seller was refusing to take the goods back. Now, what are the rights available with Mr. Das? So the questions, let us see the questions. What are the questions here? Explain the duty of the buyer as well as the seller according to the doctrine of Kevat emptor. What do you mean by this term doctrine? Wherever this doctrine is mentioned, it means principle. So there is a principle of Kevat emptor. Okay, there is a rule regarding Kevat emptor. So with in the light of this principle, you have to answer. So it is, out of the whole topic, the examiner wants you to answer it in the light of this topic, Kevat emptor. The second question is whether Mr. Das would be able to get the money back or the right kind of wood as required, serving his purpose. So let us hear it from all of you. Answers to question number 1 and question number 2. Let us discuss question number 1. Explain the duty of the buyer as well as the seller according to the doctrine of Kevat emptor. So this is a theory question. What do you mean by Kevat emptor? What are the rights and duties of seller? You can mention that very easily. Now, based on this case study, that is question number 2, whether Mr. Das, who is Mr. Das? He is the buyer. Whether Mr. Das would be able to get the money back or the right kind of wood as he required. So either seller should give him the money back or he should, give him the right kind of goods, whatever he wanted. So will he be able to get that? That is what we have to mention. So whether this relates to Kevat emptor or exceptions to Kevat emptor, we have to specify. Okay, everyone has given their answer. Okay, let me quickly take you to the answer which is there. So duty of the buyer, the theory part is there. And then duty of the seller according to the doctrine of Kevat emptor. This is the duty of the seller because whatever is mentioned in exception, that is the duty of the seller because there the seller will be liable. So indirectly, whatever exceptions we have read, those are the duties of the seller because ultimately in that case, seller will be liable. Okay, so it is the duty of the seller to give the goods of right quality, fitness as to quality. Then he has to give according to the description. Then he has to sell according to the sample and all these things. So here in this particular case, the answer to question number 2 is this one. As Mr. Das has specifically mentioned that he required the wood which would be best suited for the purpose of making wooden doors and wooden window frames, but the seller supplied mango tree wood which is most unsuitable for the purpose, Mr. Das is entitled to get the money back or right kind of wood as required serving his purpose. It is the duty of the seller to supply the goods as are reasonably fit for the purpose mentioned by the buyer. So section 16(1), we are applying this. So we are taking it into the exception of the Kevat emptor. Okay, so that is how this is finally answered. Next question. You can all read this. Mrs. G bought a tweed coat from P. So just identify who is buyer, who is seller, and what is the goods. When she used the coat, she got rashes on her skin as her skin was abnormally sensitive. But she did not make this fact known to the seller, that is Mr. P. So Mrs. G filed a case against the seller to recover the damages. Can she recover damages under the Sale of Goods Act? Can she recover? Bhumik is saying no, she cannot recover. Akshit is saying no, Mr. G cannot recover the damages. Harshit, Dakshita, Vishnu all are saying no, no, no. Reason. Ruchi also is saying no. But what is the reason? What will I write in the reason? I cannot just write no if she will not get the damages. So Bhumik has mentioned under caveat emptor. Anything else? Let the seller beware or let the buyer beware? Don't confuse. If you are saying let the seller beware, it means seller will be liable. Okay, let us see. It is mentioned according to section 16(1). Normally, in a contract of sale, there is no implied condition or warranty. So, condition as to quality and fitness, firstly, they have explained this thing. But where the buyer expressly or impliedly makes known to the seller that the particular purpose for which the goods are required are also and relies on the skill and judgment, then only this condition shall be applicable. So I'm reading the second para. In the given case, Mrs. G purchased the tweed coat without informing the seller that he about about her sensitive skin. She did not tell that. Therefore, she cannot make the seller responsible on the ground that the tweed coat was not suitable to her skin. So Mrs. G cannot treat it as a breach of implied condition as to fitness and quality and has no right to recover damages from the seller. You can directly relate it to this particular implied condition. See, it is not fit for purpose, or it the as soon as it was used, the buyer here, Mrs. G, is saying that it is not fit for use because I am getting rashes, I am getting skin allergy because of this. So can she be held? Can she get her money back and all? She will not be able to get the money back because of this reason that she has not conveyed everything. So she must have told each and every fact about her skin and the coat usage for what she will be using for. So if she has not told the purpose, if she had not conveyed the proper allergic thing about her skin to the seller, then obviously seller cannot be held responsible in this particular case. Next question. Certain goods were sold by sample. Sorry, I've given you the answer. Certain goods were sold by sample by A to B. So A is seller, B is buyer, and goods are sold by sample here, who in turn sold the same goods by sample to C. So what is happening is A has sold the goods to B by sample, and then B is again selling by sample only to C. And C again selling by sample to D. So there are, you are seeing three chain of, buyer, seller, buyer, seller, buyer, seller. So at one point of time, B is buyer, then he has become seller and there is a new buyer C. Then again, C has changed his role. He has become seller and the new buyer is D. What is the ultimate thing which is happening here? The goods were not according to the sample. Therefore, D, who found the deviation in the goods from the sample, rejected the goods and gave a notice to C. C then sued B, B then sued A. Advised B and C that under the Sale of Goods Act 1950. Can this kind of situation happen? I mean, can they be sued and whether they will be bound to get recovery from A? That is the thing. In the last case, I mean, when C is selling the goods to D, obviously D can recover it from C. For this part, we are okay. But what about B and A? Can it be recovered from them also? Let us see the answer quickly. In the instant case, D, who noticed the deviation of the goods from sample, can reject the goods and treat it as a breach of implied condition as to sale by sample, which provides that when the goods are sold by sample, the goods must correspond. So this is basically they are explaining that if the goods are not corresponding with the sample, he can reject. So finally, the finished goods reach to D. He could compare it with the sample and if it was not matching, he had the right to return the goods, obviously. So he can file a suit against C and C had to pay. Okay. Now, if we talk about whether C can recover it from B and can whether B recover it from A, we have to read it further. Whereas C can recover only damages from B and B can recover only damages from A, because for C and B, it will not be treated as breach of implied condition as to sample, as they have already accepted and sold the goods according to section 13(2) of the Sale of Goods Act. Hence, they cannot reject the goods, but they can only claim the damages. Can anyone tell me what this section 13(2) it is talking about? Anyone of you remember this? Section 13(2). हमने कुछ ऐसा पढ़ा था ना, condition is converted into warranty. Yes, Vishnu is correct. Condition is converted into warranty. When you are selling the goods further, without checking, you are selling the goods further. In that case, you have by your own action converted your condition into warranty. There was a condition that it should match with the sample. But when, without obtaining the final goods, you have sold it further to the other person, you have just supplied the sample to the other person, this simply means you are yourself, you have, voluntarily waived that condition. So now your condition is converted into warranty and now you can only claim damages. So this is what a very good example of section 13(2). Are you able to understand this example? अक्षित, उसमें हुआ ऐसा है कि इसने आगे से आगे ट्रांसफर कर दिया, तो उस केस में क्योंकि ओनर नहीं है, देखा जाए तो जब ये हम अभी यूनिट 3 में भी इसको डिटेल में पढ़ेंगे, जब आपने बिना कुछ कहे आगे पास ऑन कर दिया. ओके विष्णु, यू कैन इवन अनम्यूट योरसेल्फ एंड यू कैन आंसर और यू कैन आस्क बेसिकली. Let's see if you can unmute yourself. There was a topic where we studied that the condition can be converted into warranty. This is the best example of that. Voluntary waiver हो गया क्योंकि जब हमने वो goods बिना सोचे आगे pass on कर दिए, then indirectly they have been converted into warranty. Now you cannot claim compensation. You cannot return the goods. They have already passed on to someone else. And हमने ये भी पढ़ा था वहां पे, what was the result of it? When condition is converted into warranty, the buyer loses his right to cancel the contract. He can only claim damages. तो वो वाला कॉन्सेप्ट यहाँ पे लग गया है. And the same example I will take again in unit 3 because वहां पे ये ownership वाली बात आएगी. Whether whether they were the owner of the goods at the time when they were selling these goods. So by their action they have become the owner. कैसे बने वो हम पढ़ेंगे unit 3 में. So this is what we will study in unit 3 also. Can you unmute yourself and ask question? Ridvik, what you should do is you should write the answers, the assignments. In assignment, you will find questions as well as answer, but don't look at the answers. First, try to write it on your own and then compare it with the answers given in the assignment. It is for your, for your benefit that you write first and then you check them. Question 5, I'm just taking you to question number 5. Let me just stop sharing the screen and then I will do that. Meanwhile, if anyone wants to ask any question, please kindly unmute yourself and you can ask. The admin team, please, I request if you can just allow the students to unmute themselves. This is question number 5, if you all can see the screen.
मैम,
एक मिनट, हम इस क्वेश्चन का आंसर कर लें अक्षित। implied condition as to title means the seller option A, B, C or D.
बी
Which is
लग रहा
correct?
है।
B ही है, he has the right to sell.
तो हाँ, मुझे याद आ गया, कल मैंने इसका आंसर दिया था, आपने बताया भी था।
हाँ, he should have the right to sell। अब इसमें हमने दो पॉइंट्स पढ़े थे। एट द टाइम ऑफ सेल, सेल में इमीडिएट राइट होना चाहिए सेल करने का, एंड इन केस ऑफ अग्रीमेंट टू सेल एट अ फ्यूचर डेट ही मे हैव द राइट।
और फ्यूचर यूज में होता है।
हाँ जी। चलिए, अभी किसी के कोई क्वेश्चंस है तो आप पूछ सकते
मैम,
थे।
मैं फटाफट पूछ लेता हूँ, फिर ज़्यादा टाइम नहीं लगना, मैं फटाफट पूछ लेता हूँ अपना।
हाँ जी।
मैंने पढ़ा था आपके शुरू करने से पहले, तो कुछ कंफ्यूजन है। ये नहीं, मैं एक्सप्लेन करने को नहीं कहूँगा, मैं बस बताऊंगा कि उस पार्ट में मैं क्या कंफ्यूजन है। जल्दी जल्दी शॉर्ट में, सेल और बेलमेंट में ट्रांसफर ऑफ प्रॉपर्टी और रिटर्न ऑफ गुड्स क्या होती है? फास्ट फास्टली शॉर्ट में बता
तो मतलब फास्ट फास्ट बोल रहे हो, मुझे ही नहीं समझ में आ रहा, वापस
दो।
पूछो।
वो फिर कहेंगे कि मैं लेता हूँ टाइम, इसलिए मुझे डांट नहीं पड़नी चाहिए। सेल और बेलमेंट में ट्रांसफर ऑफ गुड्स और रिटर्न ऑफ प्रॉपर्टी क्या होती है? ट्रांसफर ऑफ प्रॉपर्टी और रिटर्न ऑफ गुड्स क्या होता है सेल और बेलमेंट में?
पहले सेल और बेलमेंट में डिफरेंस पता है क्या?
सेल से बेलमेंट मीन्स डेलीवरी ऑफ गुड्स, सुदीप सर ने पढ़ाया था, डेलीवरी ऑफ गुड्स बाय वन पर्सन टू अदर फॉर स्पेसिफिक पर्पस बाय रिटर्न, और इसके पांच सर ने फ्लो चार्ट बनाया था। रिटर्न ऑफ गुड्स, फिर डिलीवरी होती है, एक्चुअल कंस्ट्रक्टिव
अरे वो
सिंबॉलिक
सब
होती
ठीक है,
है।
अभी अभी मुझे सिर्फ ये बताओ, बेलमेंट में ओनरशिप ट्रांसफर होती है क्या?
ओनरशिप तो ट्रांसफर होती है, ट्रांसफर ऑफ गुड्स एंड सर्विसेज फॉर सम स्पेसिफिक पर्पस होती है, ओनरशिप नहीं होती।
पक्का? ओनरशिप ट्रांसफर होती है क्या? बेलमेंट का
ओनर
सिंपल एग्जांपल है, मैंने अपने नोट्स तुम्हें दे दिए, तो
यस
वो
मैम।
तुम्हारे हो गए क्या?
आपने अगर मुझे दिए,
हाँ, तुम्हारे नहीं हुए, चिंता मत करो, तुम्हें तुमसे वापस ले लूंगी मैं। तो ये
आप तो ले
बेलमेंट है, थोड़े
लीजिए।
टाइम के लिए मैंने तुम्हें दिए हैं, वापस तुमसे ले लेंगे, तो ये बेलमेंट होता है, ठीक है? तो वहाँ ओनरशिप ट्रांसफर नहीं हुई, तुम वो नोट्स आगे सेल नहीं कर सकते। अगर ये मैंने तुम्हें दे दिए होते, सेल कर दिए होते, ठीक है, तुमसे पैसे लिए और तुम्हें बेच दिए सपोज, तो उस केस में सपोज मैंने एक अपनी नोट्स की बुक्स बना रखी है और मैंने वो तुम्हें सेल किया, इन दैट केस यू बिकम दी ओनर। अब तुम उसे चाहे तो खुद रखो, चाहे तुम आगे सेल करो, जो तुम्हें करना है करो। So that is the basic difference in sale and this bailment। ये दोनों में एक तो मेन डिफरेंस हो गया।
हाँ, समझ में आ गया। नेक्स्ट जल्दी जल्दी पूछता हूँ। से सेल और अग्रीमेंट टू सेल ने मुझे ये उसका रेमिडीज में कंफ्यूजन था, और इंसॉल्वेंसी ऑफ सेलर एंड बायर। रेमिडीज मैंने पढ़ी थी कि सेलर स्यू करता है प्राइस को, अग्री पार्टी से, और अग्रीमेंट टू सेल में अग्री पार्टी डैमेजेस करती है। तो मुझे ये नहीं समझा, पासिंग ऑफ प्रॉपर्टी और प्राइस वॉज पेबल एट स्टेटेड डेट में कंफ्यूजन है, इधर का उधर, उधर का इधर।
इसके लिए भी मेरे को वापस अपनी स्लाइड खोल के फिर समझाना पड़ेगा, तो एक बार।
आप एक काम करो, स्टडी मटेरियल खोलो, किस लाइन में मुझे दिक्कत है वो मैं बता दूंगा, स्टडी मटेरियल खोल लो।
स्टडी मटेरियल वाला खोलते हैं, ठीक है? एक बार और किसी को कुछ पूछना है तो बताओ, तब तक मैं स्टडी मटेरियल ओपन कर लेती
Yes, ma'am. Ma'am, speaking
हूँ।
Arjun.
ओके अर्जुन,
Arjun.
यस टेल मी।
Yes, ma'am.
या
Good evening, ma'am.
गुड इवनिंग,
So,
बताओ।
ma'am, while studying all the conditions and implied conditions and warranties, so
हाँ,
what's the difference between condition as to means condition as to wholesomeness and marketability or marketable quality of goods? What are the three differences between them? All of
okay,
them.
let us go one by one। Wholesomeness, basically it is talking about the quality of eatables। So whenever there is a question wherein you find there are some eatables or edible thing, then straight away you should apply this condition as to wholesomeness। Are you getting my point?
Yes, ma'am.
ठीक है, वो खत्म हो गया। दूसरा आपने पूछा सपोज क्वालिटी एंड फिटनेस, तो क्वालिटी एंड फिटनेस में अदर देन एडिबल कोई भी चीज होगी वो उधर आ जाएगी, लेकिन वो तीन कंडीशन जो वो बोली थी वो सेटिस्फाई होनी चाहिए। कौन सी थी तीन कंडीशन, बताओ फटाफट। तीन पॉइंट्स लिखे हुए हैं ना उसमें। Buyer must have told his particular purpose. He's relying on the skill and judgment of the seller, and then seller is the regular dealer in those goods। ये तीनों चीजें होंगी तो क्वालिटी एंड फिटनेस लगेगा, अदरवाइज क्वालिटी एंड फिटनेस नहीं लगता। यहाँ पे समझ में
Okay.
आ गया?
Yes, ma'am. And also marketable quality or marketability of goods.
मर्केंटेबिलिटी सिंपल, अगर कोई भी कंडीशन, एक वो वाली कंडीशन रह जाती है क्वालिटी एंड फिटनेस वाली में, ठीक है, फिर भी दो चीजें आ रही हैं तो वो मर्केंटेबिलिटी में चला जाता है।
Okay, thank you, ma'am.
नॉर्मली मर्केंटेबिलिटी सिंपल मीन्स गुड्स सेलेबल होने चाहिए,
ओके,
उनकी
थैंक यू मैम।
क्वालिटी अच्छी होनी चाहिए, बट उनमें हो सकता है कि कोई वो हमारी कंडीशन उधर नहीं आ रही हो तो वो इधर डाल दिया। ऐसा थोड़ा सा सिंप्लीफाई इसको करो प्रैक्टिकल पर्पज में। आपके कोई ऐसे कई बार हमें लगेगा हम रिटर्न तो कर सकते हैं गुड्स, बट कब कौन से सेक्शन में हम उसको रिटर्न कर सकते हैं वो समझ नहीं आता। तो उसको और डिटेल में पढ़ने के लिए ये कॉन्सेप्ट है आप। ठीक है, और वो जितने एग्जाम्पल्स करेंगे ना उतना हमें धीरे धीरे समझ में आ जाएगी। एक
हाँ
मिनट,
मैम
कौन से पेज पे जाना है मुझे फटाफट से बताओ अक्षित।
हाँ हाँ मैं फटाफट करता हूँ मैम। आपको जाना है 3.11 पे मैम।
एक
फटाफट करता हूँ ताकि सारी डाउट्स क्लियर हो जाए शॉर्ट शॉर्ट में। ठीक है।
एक मिनट खुल रहा है।
3.11।
इसमें पॉइंट नंबर बोलो।
3.11 मैम।
धीरे धीरे चल रहा है, एक मिनट।
रेमेडीज ऑफ ब्रीच और इंसॉल्वेंसी ऑफ बायर एंड सेलर पॉइंट है।
एक मिनट एक मिनट। किसी और को कोई डाउट है तब तक, या हम फटाफट ये वाला ले लेते हैं। इंसॉल्वेंसी वाला और कौन सा वाला दूसरा पॉइंट, ये वाले ना।
किसी ने हाँ सेल और हायर परचेज तो मुझे आ गया समझ में। मैंने देखा था डिटेल
ठीक
में
है,
आपने
इसमें
बता।
कौन सा वाला बताना है फटाफट बताओ।
इसमें नहीं मैम सेल एंड
अरे
एग्रीमेंट से।
अच्छा, ये चले तो सही पर एक मिनट।
ये तो सारा समझ में आ गया।
पेज नंबर 11 ही तो बोला मुझे, ये वाला ना।
हाँ
ये कौन सा।
पेज नंबर 11 है। एक तो इंसॉल्वेंसी ऑफ सेलर और बायर में ऑफिशियल असाइनी में दोनों में कंफ्यूजन है कि एक तरफ टेक ओवर कंट्रोल और कंट्रोल
अच्छा एक
दोनों में।
मिनट एक मिनट एक मिनट, ये सब समझ लो कोई बात नहीं है। एक तो ये इंसॉल्वेंसी वाला, इंसॉल्वेंसी में क्या होता है, कोर्ट एक इंडिपेंडेंट पर्सन को अपॉइंट करता है, उसका नाम ऑफिशियल असाइनी रख देते हैं। तो सपोज सेलर इंसॉल्वेंट हो गया, ठीक है, सेलर इंसॉल्वेंट हो गया तो हमें कोई फर्क पड़ता है क्या। सेलर ने हमें गुड्स ऑलरेडी दे दिए,
इस मैम।
है ना, सेलर ने हमें गुड्स दे दिए, हमने उसको पेमेंट कर दिया है सपोज। अब कोई भी इंसॉल्वेंट होता है हमें कोई फर्क नहीं पड़ता। तो ये इंसॉल्वेंसी का टॉपिक क्यों लिया है इसको ऐसे समझो। सेल के केस में ओनर कौन है, आपने जब मेरा सेशन भी देखा होगा पहले तो मैंने ऊपर ही लिख दिया था ओनर कौन है, वो बड़ा इंपॉर्टेंट होता है इसके अंदर, हु
यस
इज द
मैम।
ओनर। ठीक है, तो सेल के केस में ओनर कौन है, बायर इज द ओनर। तो जब भी ऑफिशियल असाइनी यहाँ पे अपॉइंट हुआ है, सेलर का ऑफिशियल असाइनी, सेलर का ऑफिशियल असाइनी अपॉइंट हुआ है, तो सेलर का ऑफिशियल असाइनी करता क्या है, जहां जहां पे भी उसको असेट्स दिखाई देंगे वो वहां से कलेक्ट करेगा और बेच के उसके जो भी लाइबिलिटीज है उसको पे ऑफ करेगा। ऑफिशियल असाइनी का काम ही यही होता है। पहले तुम्हें ऑफिशियल असाइनी पता है कि नहीं पता वो मुझे समझ में नहीं पता। ऑफिशियल असाइनी
ऑफिशियल
कौन हुआ।
मैम मैं बताता हूँ ऑफिशियल असाइन वो होगा जो मतलब ऑफिशियल जो सेल में वो मतलब उसको वर्क असाइन करता है। वो काम असाइन करता है उनको।
से ऑफिशियल असाइनी कोर्ट का एजेंट है। कोर्ट एक
एजेंट
पर्सन
है
को
कोर्ट का।
अपॉइंट करता है, कोर्ट एक पर्सन को अपॉइंट करता है, उसका काम क्या है, सेलर कहीं अपनी चीजें इधर उधर किसी को फ्री फोकट में दे ना दे, एक तरीके से प्रॉपरली उसका अरेंजमेंट हो जाए। तो उसके लिए एक पर्सन को अपॉइंट किया है कि सेलर की अब जहां भी जो भी असेट्स हैं उनको सेल ऑफ करके और लाइबिलिटीज को पे किया जाएगा। वो काम कौन करेगा, ये ऑफिशियल असाइनी। सेलर खुद नहीं कर सकता, उसके बिहाफ पे सारा काम कौन करेगा, ऑफिशियल असाइनी करेगा। तो ऑफिशियल असाइनी देखता है जहां भी असेट्स हैं वहां से वो लेगा और फिर फाइनली पे ऑफ कर देगा। तो जब सेल हो गई है, गुड्स की सेल हो गई है, तो ओनरशिप ऑलरेडी चली गई है किसके पास, बायर के पास। तो सेलर तो ओनर है ही नहीं, तो ऑफिशियल असाइनी कैन नॉट गेट द गुड्स फ्रॉम द बायर। ये पॉइंट यहाँ लिखा हुआ है, फर्स्ट पॉइंट।
हाँ बस। हाँ बस लास्ट है। लास्ट लास्ट मैं फिर करता हूँ। लास्ट ये है मेरा कंफ्यूजन। कैव टेम्प्टर ने प्रीस्ट वे पैरिस क्या है, बस यही है और सारी डाउट क्लियर। क्या है
क्या है,
स्टडी मटेरियल ने प्रीस्ट वे पैरिस से पहले मुझे डाउट है बस। लास्ट डाउट है मेरी।
नहीं तो मैं कहाँ देखूँ।
स्टडी मटेरियल यूनिट 2 में।
यूनिट 2 खोलूँ अब, उसमें क्या देखना है।
बस ये लास्ट ही डाउट है बाकी सारा क्लियर कर लिया मैंने अपना।
अरे वो तो ठीक है, पर क्या देखूँ, टॉपिक तो बताओ।
सॉरी कैवी टेम्पटर जो पेज है ना
हाँ
3.35 से शुरू हुआ है। उसके
हाँ
बाद एक पैरा है 3.36 में, तो उसमें फिट एक्सेप्शन में फर्स्ट पॉइंट के बाद उस पैरा में बस डाउट है।
उसको रीड कर दो फटाफट, मैं खोलूंगी उससे बेटर है रीड ही कर दो। ऋत्विक आप
आई एम
पूछ रहे हो डू वी नीड टू राइट द नोट्स गिवन इन द पीडीएफ और जस्ट रीड देम, इट इज अप टू यू व्हाट यू वांट टू डू। असाइनमेंट्स अगर हैं तो वो आप लिख के कर लेना बस, है ना। इफ देयर आर एनी असाइनमेंट्स देन यू हैव टू राइट दोज आंसर्स, देन मैच विद व्हाटएवर द आंसर्स आर गिवन।
पेज नंबर 3.36 में पढ़ रहा हूँ, पेज
हाँ
नंबर 3।
पढ़ दो फटाफट।
यस, मैं कर रहा हूँ, 1 मिनट का। हाँ। P, an order was placed for some trucks to be used for heavy traffic in a hilly country.
अभी
Trucks
तो अपन ने
supplied by the
एग्जाम्पल किया ना, अभी अभी एग्जाम्पल
उस
किया था
उसके
उसके।
उसके बाद मैं वहां से पढ़ रहा हूँ, ये तो समझ में आ गया, उसके बाद कंफ्यूजन है। टू
हाँ
पैरास इन प्रीस्ट लास्ट, ये पैरा पी से पी है, कुछ लिख रखा है हॉट वाटर बॉटल। ये बस समझ में नहीं आया मुझे, ये दो
मैं हॉट
पैरा।
वाटर बॉटल वाला केस समझ में आ गया क्या?
हाँ, वो आपने बताया
वाटर
था,
बॉटल
उसने
बस तुम
परचेज
अपना
करा था।
उसकी लैंग्वेज जो भी लिखी हो मॉड्यूल में कोई बात नहीं, लैंग्वेज तुम अपने हिसाब से बना लो, वर्ड टू वर्ड हमें मॉड्यूल का नहीं पढ़ना। अगर जहां भी कंफ्यूजन लग रहा है, आपको कॉन्सेप्ट क्लियर हो गया, आप अपने हिसाब से अपने लैंग्वेज में लिख दो, कोई दिक्कत नहीं है।
हाँ हाँ, बस उसका स्टडी मटेरियल में से शॉर्ट में समझा दो, होगी
बस
मेरी डाउट क्लियर।
तो वो वही है, प्रीस्ट वर्सेस लास्ट वाला केस वही था, हॉट वाटर बॉटल वाले केस के अंदर जो समझाया था ना आपको अभी पूरा। डैमेजेस क्लेम कर सकते हो ना आप दूसरी पार्टी से, क्योंकि यहाँ पे गलती किसकी थी, सेलर की गलती है एक तरीके से। सेलर को हमने अपना पर्पस भी बता दिया था, हमें क्यों चाहिए हॉट वाटर बॉटल, एंड वो रेगुलर सप्लायर था उसके पास। हम गए तो क्वालिटी एंड फिटनेस का कंडीशन ब्रीच हुआ। और ये केवट एम्प्टा में भी हमने एक्सेप्शन में इसको डाला हुआ है। केवट एम्प्टा में नॉर्मली बोला जाता है बायर हैज टू बिवेयर, लेकिन बायर उस केसेस में लायबल नहीं होगा जहां 16(1) एप्लीकेबल होता है। तो 16(1) वाला केस था ये प्रीस्ट वर्सेस लास्ट वाला, इसलिए ये यहाँ पे एप्लीकेबल नहीं हुआ, है ना। तो प्रीस्ट वर्सेस लास्ट इज एन एक्सेप्शन टू केवट एम्प्टा, यानी यहाँ पे लायबल कौन हो जाता है, सेलर। ये है सिंपल सा इसका।
थैंक यू मैम वेरी मच फॉर, थैंक यू वेरी मच फॉर क्लियरिंग आउट, सब समझ में आ गया आज का मुझे।
चलो देखो अब असाइनमेंट्स करो, आंसर्स आप लोग कर सकते हो।
असाइनमेंट मैंने कर लिया यूनिट 1 का, यूनिट 2 का अपलोडेड नहीं है।
ठीक है ठीक है। ओके, एनी अदर
थैंक यू।
डाउट बाय एनी ऑफ द
थैंक यू। थैंक
पार्टिसिपेंट्स?
यू, नाइस
ओके
सेशन।
जी, ओके ओके, देन कैन वी वाइंड अप?
Yes, Divya, we can wind up.
ओके
Thank you so much.
ओके
Now
मैम।
we will meet on Wednesday. Next class, Unit 3, we will start. Unit 2, notes and assignment. I have uploaded on the VUS Knowledge portal. I think it will be uploaded by the technical team also. So you can try the questions by writing, as Divya ma'am is rightly correct. Whatever the questions are given in the assignment, just do the writing practice of the same and match your answers with the answers provided in the assignment. And on Wednesday we are having CA day, so it's a very special day for all of you. So we will have a class on that day also. And on 3rd July the result for May 2026 is about to come. It's announced on the ICAI website. So as soon as the result is published, if any student is there who has given the May 2026 exam, they can see the suggested answer. The suggested answers will be uploaded within 24 hours of the result, so they can see the improvements or whatever the problems they have, mistakes they have committed in May 2026 examinations, so that mistakes will not be repeated in September 2026 examinations. And the new students who are giving first time in September, they can take the questions from the suggested answers and they can practice the same. So thank you so much, Divya. See you on Wednesday. Thank you.
Bye.
Bye.
थैंक यू मैम, एडवांस।
ओके बाय।
बाय मैम।
Recording stopped.